Special meeting of Tuesday, November 9th is in session. Are there any changes to the agenda? Okay. Seeing none, our agenda is approved as submitted.
Mr. Mayor, before we start, I did ask Mr. Woods this, and I thought we may have some people out in the viewing audience who don't know whether or not the veteran ceremony at Kettering Park on Thursday will go no matter what the weather.
And the email I got this morning was rain or shine, they ain't moving it.
Okay, I just wanted people to know that in case they happen to be listening or watching.
So rain, shine, sleet, snow.
Yep, just
They've never canceled one.
yes.
Never have.
And
Big snowstorm.
Yeah, well, they never cancel any of those.
the pictures from 10 years ago, if you go look, show everybody covered with snow.
Icicles hanging off our
Yes,
noses.
icicles hanging off the noses. So this year may be no different. All right. Our first item is a discussion with our new presiding judge, Judge Anderson, about various aspects of the court. You'll remember last week I suggested that perhaps it would be good for all of us to get a little background. First, talk about what happens in the court during the week. So, what happens in the court?
A lot happens in the court. Let me give you a little bit of background first. Our court, as it presently stands, has court 4 days a week: Monday, Wednesday, Thursday, and Friday. Each is a little bit different. At one time, our court was a 5-day-a-week court. Fridays have traditionally been held out for jury trials. And because of the decriminalization and the changes in our docket and our numbers, the number of jury trials is significantly less than it has been. I think the city attorney told me we decriminalized how many years ago?
It was actually last year ago.
A year ago, a little over a year ago.
Maybe last February.
And that has affected our numbers. As it stands right now, Monday is our day for trials, pre-trials, and motion hearings, primarily. And let me just say that on every day of the week, so we have our counter kind of going vertically and horizontally, at 11 o'clock on every day of the week, we have an agreement with the Arapahoe County Jail to do the in-custody advisements. And we do that by video, generally, although the video is not working now because they're remodeling the room in the jail, and we're doing it by speakerphone. We do those at between 11 and 12 if there are people in custody. On a typical day, we have anywhere between 3 and 6 people that would be in custody that we would see at that time. So other than that, on a Monday, we have pre-trials, some trials the court said in the morning prior to 11 o'clock. This past Monday, I think we had 1 trial set before and about 8 or 9 pre-trials. And those are generally cases where attorneys have entered, they've never had a chance to speak to the prosecutor, cases where somebody on an arraignment day, which is our Wednesday days, didn't have enough time to speak in depth with the city attorney and wanted to have more time. And we set those over for discussions. They ultimately result in either a plea or setting for a trial. In the afternoons, primarily we have restitution hearings or other motions hearings set in the early afternoon, 1:32, and trials set after that, anywhere between 3 and 5 trials. On a typical day, we will have some who fail to appear. Usually the officers are there, the prosecutors are ready to go, but the defendant fails to appear, warrant needs to be issued, trial doesn't go. We'll have a couple that will probably go, and we may have some that resolve it with a plea agreement at the last second. And that's our typical Monday. Tuesday was a day before we changed our docket that was general arraignments. And when I say arraignment, an arraignment is the first day that somebody is coming into court on a ticket. The officer will call dispatch, get a date and a time to put on the ticket. The first time that they come in is an arraignment date. That means it's a date that they would enter a not guilty plea and set it for trial, enter a guilty plea to resolve the matter, or enter into a plea bargain with the city attorney. Tuesdays were lumped into Wednesdays as we decriminalized, so Wednesday is now our busiest day of the week. I pulled a couple of copies of the doc, which I'll just pass around so people get an idea of what our Wednesdays look like. On Wednesdays now, In the morning, we have the first appearances of people, arraignments for general offenses. And general offenses are municipal code violations other than traffic. They can be assaults, thefts, trespasses, things like this. We have a special time allotted for our zoning violations. They can be animal control issues, anything like this. In municipal court, these are generally where jury trials come from. Maximum penalty for an offense is up to a year in jail, up to a $1,000 fine. So in the morning, we'll have anywhere between 20 and 60 cases. I think on this particular date, we had about 25. The procedure that we have now is that when people come in, they'll check in with the court clerks, and they will then go into our large room on the first floor for seeing the videotape, which we have now just done, the DVD, I guess I should say, as technology has gone forward, which is an arraignment, advisement of rights it's done. Then they go and see the prosecutor, and then after they've had a chance to talk to the prosecutor to see if they have a plea disposition, they come into the courtroom for the court to take the guilty plea advisement of their rights, what we call a Rule 211 hearing. And we do that in every case where there's a plea that's being entered. If a trial is being set, we accept a not guilty plea and then set the matter for either trial to a court or jury trial, advise them of their rights to counsel, their right to a jury trial, and the like. The afternoon,
Judge?
Yes.
Quick question, because you've mentioned typically Fridays jury trials and Mondays trials.
Right.
How does it get determined whether it's a jury trial or a trial without jury?
There's two parts to that. One is, does the statute or the municipal ordinance provide for a jury trial because of the possible penalties? In the traffic ones, which is what's in the afternoon, other than a very few, no proof of insurance, careless driving, reckless driving, speeding over 24 miles per hour, passing a school bus, those ones have a jury trial right because there's a possibility of jail. Almost everything else has been decriminalized. It's fine only. In those cases, they only have the right to a trial to the court. If they so choose, in a case, a general ordinance violation or one of those traffics, they can have a jury trial upon filing a written demand and paying the jury fee. They have 20 days to do that. Some people who are entitled to jury trials don't request them. In those cases, the matter is set for a trial to the court. So some of it's statutory and some of it's the choice that they have in selecting what type of a trial they want.
Thank you.
So the afternoon, we have anywhere between, I would say, 50 and on this particular day, I think there was 85 cases of traffic. They can vary from speeding, failure to yield right-of-way, no insurance, careless driving, pretty much anything with an accident is going to come in, following too closely, improper backing, those type of things. Again, the same procedure is done. They check in with the clerk, they see the prosecutor, they come into court. If you do the math and you realize we have almost 90 cases here, what that means is that everybody, if they come into the courtroom in the 3-hour session, which is kind of the normal session between 1:30 and 4:30, gets 2 minutes. And that means that I'm doing an advisement, answering questions, and taking a plea with a different person every 2 minutes for 3 hours. And that's about what our docket looks like on days like this. Unfortunately, in those type of days, it's very difficult to do other things. So if somebody shows up on one of those days and they're not on the regular docket, it's a little more difficult to get them in. If we have an officer that wants to get a warrant approved, it's a little more difficult to get them in. If we have a lot of people that are in custody, we're constantly trying to juggle the time to get those type of things done. So these are by far our busiest days. They can vary anywhere up to, I think the most I've done in a day is 120. We generally try to start at 9 o'clock in the morning and 1:30 in the afternoon. And I try to get there early to be able to take care of the other things that could be done on paper, issuing warrants, reviewing inmate letters, these type of things before court starts, and then try to hit the ground running as soon as we have somebody that's available, particularly when we have one of these longer dockets. And that's our typical Wednesday. It's the main intake of cases in pretty much any form that we have. Thursdays right now are divided. The first and third Thursday of the month, we have full day in court. Because we have a prosecutor available for half a day, the afternoons, the morning is a bench probation or review. So if I've sentenced somebody, or Judge Julie Anderson Hemmett, I'll call her Judge Hemmett so there's not the confusion between the two of us, or Judge Chris has sentenced somebody, Many times, the plea agreement in the case or the sentence will be conditioned upon many factors, and one of them frequently is that there's no further offenses committed by the defendant for a period of a year. So we will set a couple of review dates, many times one a month or 2 months out, to make sure that things are getting in the process where they need to be. Domestic violence class registered for, community service completed, traffic, school done, something like this. And we'll have a final review a year out to make sure that everything has been complied with at the end of the amount of time we have to sentence somebody. Those are things like making sure that the fees have been finally paid off, again, that the classes or community service are done if they were started, and particularly that there are no further offenses. So we'll have somebody run a CCIC, NCIC, it's Colorado Crime Information Center, National Crime Information Center, criminal history run at the end of that year time period, generally about 50 weeks in, to see if those people have complied with their sentence. If they have, in many of those cases, we will then vacate that hearing so that we don't require people to come back simply for a formal dismissal or closing of the case. If we can do that, it's more efficient, and we try to do that at about that time frame. So the morning is particularly done for those type of reviews. We don't generally have a prosecutor there available for new people that would come in, although we do still have the 11 o'clock in custody advisements if anybody happens to be in jail on that day. The afternoon is set for mostly trials. It can be pretrials and hearings and trials. We have our prosecutor, so we have the ability to work like we do on the Mondays for either actually holding the trial, having a plea agreement, or something like that that comes up. Fridays, and that, I said, that happens on the first and third Mondays. We have the full morning and afternoon session. On the second, fourth, and in months where there's a fifth, we do the morning reviews, the bench probation reviews, the in-custody advisements, but we do not have any trials that are set. And this is something that the prosecutor, the city attorney, and I, and the deputy city manager have kind of worked with, trying to fine-tune it to meet the balance between having enough time so that we don't load everything onto Monday and make that unwieldy, at the same time using resources appropriately so that we don't bring in a prosecutor unnecessarily if we don't have enough. And we had full days for Thursdays. We've now gone to this 2 out of every 4 or 5. We're trying to strike the appropriate balance there between those competing concerns. Friday, again, is reserved for our jury trials. Jury trials are a bit more intensive when they go because we have to get a jury summons out to potential jurors. Of course, anybody in Littleton is subject to also getting a jury summons from either Arapahoe, Douglas, or Jefferson County, as well as Littleton, so we always kind of have to share that with them. People like to know ahead of time if they're really going to be required to come in, because obviously they could be at work, they could be with family, they could be at school, they could be taking care of someone who's ill or aged or something like that. And so we try to let people know. I know just this past week we had a lady who was 90-some years old and called in and said, am I really going to be needed because, I'm in an assisted living center, it will be difficult, but I will come if the court needs me. And I love that kind of attitude as opposed to someone who says, how can I get out of jury duty? But at the same time, we want to be responsive to those people so that if we need them, we call them in, and if we don't, we let them know ahead of time so they can go on with their lives. So that's our Fridays. If the jury trials start, they generally get done in a day. They can go longer hours if need be, into the evening so that we can resolve it and get the case completed and get the jurors released and the witnesses as well. That's kind of a picture of what the court looks like at this time. Again, the Mondays are kind of a hodgepodge of pretrials and trials. Wednesday, the main intake day. Thursday, the review and the carryover trial date. And then Friday, our jury trial days. The next thing that I saw that there was a request is the type of offenses that we have.
Can I ask some questions?
Sure. Yeah, if you have questions as we go along, please ask them.
Yeah, I have 3 questions. On jury trials on Friday, do you come from pick the jurors from a pool, or are they pre-selected to be there for a specific trial?
We only have one jury trial that's set per Friday. So we draw from the general pool, and then as a part of the process of a jury trial, the maximum number of jurors allowed by law for a municipal case is 6.
Right.
Each side gets 3 peremptory challenges. Those are challenges where they can strike a juror and they don't have to give a reason. So that adds 6 to that, meaning we have to have at least 12. And then we have challenges, which are called challenges for cause. And that's generally a situation where a potential juror may know the defendant or may have some personal knowledge of it, or knows the officer, or is a relative of a government employee, something like that. So we always try to hold a few just for challenges for cause, and that happens in most trials, 1 or 2. And then we may have some alternates, and that would be if we had someone who couldn't serve out for some reason the entire trial. So that amount that we would call in would be somewhere in the neighborhood of 15 to 20 to have enough people so that we could have the challengers for cause, the peremptory challenges, the jury that we finally seat, and then some alternates if need be. But they're not assigned, for instance, we don't say you're assigned to this case and tell them what the name is or something like that. They're assigned by day, and it just depends on which case happens to come in on that day.
You talked about things that were decriminalized and things that were not. Would there be an advantage to the city to work toward more decriminalization of the laws in order to keep some of the workload down?
I don't know that would be something I would recommend. I can give you an example of a couple of different cities that I'm pretty familiar with. One of them is Centennial. Centennial is now home rule. They've been around for, I think, maybe about 10 years now. They are totally decriminalized. There are no potential jail sentences out of Centennial. They have no city jail. They have no police department. All law enforcement is contracted with Arapahoe County. Most of the things that come in go to the Arapahoe County courts, particularly anything like careless driving, DUI, no insurance, something like that. If they're infractions, and that's a case that's a fine-only type case, they can come to the city of Centennial. Their workload is actually kind of similar to ours in that they have Mondays and Tuesdays where they intake their cases, and Wednesdays set for trials to the court. They don't have court on Thursdays, and Friday they only hold court if Monday, Tuesday, or Wednesday is a holiday or something like that where they can't hold court. So the number of days a week is kind of similar to what we have if you exclude our jury trials. And they do just fine like that. They are able to maintain the law in the city. They're able to maintain an appropriate caseload. As population is going up, the number of cases are going up. That's a totally decriminalized city. The city of Aurora, on the other hand, is not. It does have infractions, but it has general ordinance violations and traffic violations and juvenile violations, all of which we have to some extent here. They have probably more of them there, but because of the population base, they have 5 full-time courts. They have a police department. They have a jail, a municipal jail. And they also have Adams and Arapahoe County jails and the sheriff's departments that support them. In that case, they do a lot of jury trials. They have jury trials set probably, I would think about 60 jury trials a week commonly, set between those divisions. They can only try so many of them, so they might try 8 or 10 a week. But that's a totally different kind of model of a court. We're somewhere in between that. We can do all these things, but I don't think that it would be helpful to totally decriminalize our laws in an attempt simply to reduce the number of cases that come into our court. Because what's going to happen is the things that we decriminalize will likely go to Arapahoe County. So they'll still be done, they'll be done someplace else, and it'll require our police officers to travel out to Arapahoe County, causing more expense to the city. And I don't think that it would necessarily reflect in less violations.
A third question is, I'm assuming there's a single judge on Wednesdays, and I was somewhat bothered by your comment about spending the amount of time you do per case that comes before you. It seems like that if I were a citizen, and it seemed like I'm getting the brush off all the time. And I wonder if we need to increase the number of judges we have on Wednesdays to lengthen that amount of time you have face-to-face with your clients.
That is always the balance. That is the real challenge in court. And I can tell you that it's not unusual to our courts. In Aurora, where I sit as well, it's very common to have a similar number in a similar time period. What we always try to do, we have to make it long enough to make sure that the person is heard and has their questions answered, but short enough that people don't feel like they're having to wait and sit there and not get anything done. Long enough to cover the rights advisement adequately, make sure that the record is appropriate and the time is given for someone to say what they feel they want to say and for the court to consider all the appropriate factors, but short enough that the staff can get what needs to get done in terms of data entry, movement of people around, payment of fines and all those type of things done within the same time that they have to operate. When I'm in the courtroom, or Judge Hemet or Judge Chris is in the courtroom dealing with the number of people on Wednesdays, our staff, and it's varied between 4 and 1, depending upon the day, and the fact that we've had some people that have left or been on maternity leave, they are trying to do all the other things in terms of moving people around, set up payment plans, get class information to people, get them checked in, get them checked out. They're probably even busier than the judges are. If we had a second judge, we only have one courtroom. I mean, we could open up the upstairs courtroom, then we'd have to shuttle people between 2 different floors. As it stands right now, we only have one security officer who is wanding and making sure that the people that come in aren't carrying weapons or doing something else that would endanger the staff or the court or the other people that are there. And we couldn't really have him at 2 places at the same time. So it does complicate factors if we were trying to open 2 courts at the same time.
Unless you did like Denver where they do it at the doorway.
Our courthouse, it would make it difficult. It could be done. There's an issue for another day, and that's courthouse security. And I'll just tell you that having been in a lot of courthouses, our courthouse, probably because of the age and the design, is not as secure as many courthouses are these days.
Understand that.
But that's a discussion for another day. Did that answer your question?
Yes, thank you very much, sir.
Judge, before we move on, just to piggyback on Jim's question, you're spending 2 minutes with them, but they also have some time with the prosecuting attorney. I mean, there's other time that's spent with someone that's in the court.
Correct.
It's just with regard to your time. When they come.
And what I'm saying, really, my time is an average. So there may be some people that I spend a lot more time with that. And if I have a day where I don't have, the 83 people and I have maybe 50 people, obviously it gives me a little bit more time to handle an individual person. But when they come in, they're getting a chance to see the clerks at the counter when they check in, get some questions answered there, at least in terms of where to go and kind of how the procedure works. They get a chance to talk to the prosecutor who can go over the options that they have, the plea agreements the officer have made, the paperwork that's done at that point. Sometimes community services is an agreed part of the plea agreement, and the paperwork for that is done. Then they come and get a chance to see me. Then after they're done with me, they go back out to the counter to talk to the clerks there to arrange for payment of fines, classes, get future court dates and those type of things. So we're all trying to be efficient. We kind of have a circle, almost a physical circle, where people are coming in and kind of hitting each station as they go through. I try to make a point of people getting a chance to get their questions answered. And the question that I ask people more than anything is, do you have any questions? Because a lot of times people are afraid to ask a question if they feel like that they don't have the opportunity. And I want to make sure that people that come in get a chance to ask questions and get a chance to say their piece, because I think a lot of people that come in, this may be the only time that they see the court. It may be the only time that they see their municipal government or any government. And a lot of people will take their opinions of that from their interactions in court. So I want to be able to take the time to answer those questions and make sure that people feel like they got heard.
It looks like we're doing about 2 trials a month.
Now, are those numbers for actual trials held or trials scheduled?
Good question. It just says court activity, trials to the court. October we have 2, September we have 2010, 3.
These would, these by month?
Yeah. You got 4 in August.
Yeah, the number of jury trials a month is going to vary between 1 and 5, depending upon how many Fridays are in a month. You set 1 per Friday, so that number is always going to look like that. The trials to the court, I can tell you that we didn't have 2 trials to the court in the month, because any time that I've been there on a Monday or on a Thursday afternoon, we had more than that. There were 7 in the docket. Now, one thing that these figures sometimes show is they may show how many trials actually end up going to completion. And that's different than how many we schedule. If somebody comes in and requests a trial, we set it. And if we set the this last Monday, I think I had 5. If I have 5 trials that are set, all 5 trials may not go, particularly if people don't show up. Now, the city prosecutor has to be ready. They have to have witnesses ready, because there's no way that they know whether that person is going to come in and demand their right to have the trial, if they're going to fail to show up, or if sometimes they'll come in and they'll simply plead guilty to the charge on the day of trial. The only one that gets recorded, if we're looking at actual trials done, would be the first one, people that came and actually did their trials. But in all those other ones, the time that we allot for it and the work that the prosecutor does and the staff does is the same, and we don't know which ones will go and which one.
Well, I guess the question then is, Phil, if this isn't the number of trials that are scheduled, when it says trials to the court, what is the number? And if this is just the actual number of trials that happen?
It says pending.
Pardon?
It says trials pending.
And that could be over a period of 6 weeks or a month, but this is the number of actual trials that go to trial. And there are a number of reasons that a trial could be set and not go. Probably a third of the cases, the prosecutor does know in advance. There's some kind of plea agreement worked out. The person calls in advance, or the attorney, and says, we don't actually want to go to trial. And so they may have some plea disposition, and they'll notify the clerk's office that the trial's not going to go. So these aren't all prepared, but...
So the pending is just how many cases are ready to go to trial or set to go to trial at that particular month?
Right, and it could be that month, the next month, the month after that. Those are the number in the queue, so to speak, that are set.
In municipal court, our trial period, our speedy trial period is 90 days. That means that from the entry of the not guilty plea, which is generally the first time that somebody comes into court, until the trial has to be held, is 3 months. So a number like this would most likely say how many cases are currently set for trial over the next 3 months, because we're not going to have any trials set outside of those 90 days.
And Doug, if I'm reading the numbers, the actual trials to court year-to-date through October were 67, so it was averaging more like 6 to 7 a month, although the last couple of months don't have that many in.
Well, yeah, when I thumb through here, it looks like we're having 4, 5, 6, sometimes highest number is 7 a month that actually happen.
I was looking at the year-to-date numbers for 2010, so that's where the 67 shows up on the front page.
So that means that we're a little less than 2 a day, figuring that they're spread out on that we have 4 Mondays in a month.
But there could also be ones on Thursdays.
Pardon?
They could be on Thursday afternoons as well.
And the reason I'm asking this is, if we're not having enough time to do arrangements on Wednesdays, then should we not do that on some other day of the week in addition?
Well, it used to be that they were done on different days. I mean, they were done on Tuesdays and Wednesdays, and that spread it out a bit. When we decided to go back to eliminate Tuesdays, everything got put onto Wednesdays.
Well, I'm thinking Mondays or Thursdays. I mean, if we have 2 trials, if we have less than 2 trials every week.
Again, those are ones that end up going.
But we have talked about that, about moving some of the general offenses to a different date. Initially, when we picked Monday and Thursday, it was the primary reason that we picked Thursday was to accommodate officer schedules. Some officers work the first half of the week, some officers work the second half, and we didn't want to put all the trials on a Monday or all the trials on a Wednesday because it would have required more overtime. At the time that we decriminalized, there were quite a few more trials that were set, and we kind of had to wait for, about 120 days for all those cases to get out of the system. So now we're starting to see a flattening of the numbers, and I think that we could look at trying to stagger. I think at one point we had talked about maybe having all the general offenses come in one day and the traffic offenses another, just because general take more time. They tend to back up the traffic. So we have had discussions about moving that docket around a little bit.
And it does implicate the prosecutor's office as well, because if, say, we moved our general offense, and we talked about this, from Wednesday morning to Thursday morning, then we're going to have the prosecutor there on both of those times, whereas generally Thursday mornings were the bench reviews, and the prosecutor's not there. So by doing that, it affects several different things, and that's something that we can't do in a vacuum. We really need to talk about it ahead of time. Those bench reviews that are set on Thursdays now are set a year out. So to suddenly, if we decided to change next week, for instance, the general offense arraignments to Thursday morning, we're going to be competing with our reviews for the next year until those things finally clear off.
Okay. Other questions?
The next topic on here, type of offenses, and I've already kind of talked about some of them. Traffic is by far the largest that we have. We're under the model traffic code, very similar to most cities. I think we're in the process of adapting the new model traffic code. The offenses are municipal ordinance violations. As of the last month, we've added about a half a dozen, I think, offenses. Ones where the state provided for an offense that would be prosecuted in Arapahoe County Court as opposed to the municipal ordinance, which we have here. We've augmented some of those. In addition to general and municipal offense violations, we have animal control violations, and those can be anything from too many animals to barking animals to animals running at large or not licensed. We have zoning violations. Those are generally set on our Wednesday mornings. Zoning violations can be anything from unlawful outdoor storage of materials, building materials, vehicles that aren't operating, general maintenance and landscaping of a house. Those all come through as well. We have statutory authority for sales tax violations. We have photo red lights, which we do on Monday afternoons at 3 o'clock, and they vary anywhere between 6 and maybe 20, depending upon how many happen to go through the photo red lights. So these are the type of offenses that we have. The ones that are most likely to set trials tend to be the general offense ones, and some of the more serious traffic. Most of the other ones, at least my experience is, we're not setting too many trials on.
So photo red lights, you're getting a lot of people coming into court on that?
Photo red lights are tickets that people can mail in. If they want to contest them, they can come into court. We have a system in the courtroom where the prosecutor can bring up the video from the particular driver. And many times when a person says, well, it's not me, I didn't do this, and the prosecutor says, well, okay, here's our tape. And it shows the license plate, and it shows the light, and it shows the driver. And they can stop it, they can move it forward and back. And I would say most of the people that come in then say, oh, okay, I'll just take care of that and pay it, and I'll be on my way. Occasionally we'll get some people who the ticket will go out to the registered driver of the vehicle. It might be that it's a relative, parent, spouse, something like this, and it's not unusual for somebody to come in and say, all right, I'm the one that actually went through, not this other name here, and I'll pay it and take care of it. But they can't do that by simply mailing it in, because obviously it would go under the other person.
So
Now,
when they're coming in to look at the tape, I assume that that's happening all with the prosecutor and not...
that's correct. That's correct. We actually leave the bench to do those and then come back in to do the dispositions. Guilty pleas, send them out, or dismissals. Sometimes the city will look and say, this isn't the person that's here, or the picture, there's too much reflection or something like that. Now these are offenses. The difference between the photo red lights is most of the traffic offenses carry with them points, points against your license. Anywhere between 1 and 6 is the norm. We do have some 0-point violations as well. Photo red lights, although running a red light under the model traffic code is a 3 or 4-point violation, depending on how it works, the photo red lights do not carry points with them. So they're not reported to the Department of Motor Vehicles and don't affect somebody's license. They do carry with it the fine, and that's collected by the vendor that the city contracts with. So the payments that they make, they end up actually mailing those in. Any other questions on any of the offense types? The next thing on here is the on-call procedures. I had submitted to Councilmember Stallman last month, and I just gave him today some schedules of the judges who's assigned on any particular day for the general covering of the court sessions. We also have to have people on call in case we have someone that's arrested on Friday, or if somebody's arrested late Friday after court, and we need to do a what's called a Riverside hearing. Came out of a court case in California that states that the court has to review a warrantless arrest, someone who was arrested without an arrest warrant previously issued, basically we call probable cause arrest, within 48 hours. So we have myself and Judge Hemmett that cover every other month. So for instance, the month of November is my month, and I'll check in with the police department dispatchers on Saturday, Sunday, and Monday holidays, and Thursdays if we have a holiday like Veterans Day or Thanksgiving coming up, so that if there's somebody that's in custody, we both have fax machines at our homes. They fax the warrant application to us. We review it, determine if there's probable cause, check it off, fax it back so that they have that probable cause determination and we've complied with the law. The jail is notified of that, and then they're brought in the following court day. On a very long weekend, if we had, say, a Monday holiday and Tuesday not having court, somebody could be conceivably in the jail from Friday night until Wednesday morning. So we'll have that probable cause determination done on Saturday or at the latest on Sunday to make sure that there's probable cause to hold those people. We also will be available for actually coming into court to do the video advisements on Fridays if somebody has been arrested, say, anytime after the court session, Thursday around noon until Friday morning, so that we can take care of those as well. So we have someone that's on call, and I put them on the calendar with the designation OC, so that you'll know who is available to do that, and we just trade off that duty by month. And that's how that works.
Jim, Bruce had forwarded earlier the October court, at least when he forwarded it to us, there was no one on call on Fridays, but...
Right. We had them, but I didn't put them down there because that was the first time I'd done one of those. And now I think I made it a little bit easier. We had somebody who was on call, but it just varied. As you can see, I think on those ones... Yeah,
it's a rotation.
It's kind of who can be available and making sure that there's somebody available every day. And then the court clerk has it, so if she needs to call one of us to get us to come through to do those, we do.
There's no one denoted on Tuesdays in November, is that?
There's no one denoted on Tuesdays at any time. And part of that is because we're allowed 48 hours under Riverside, and there isn't 48 hours between Monday, unless there's a Monday holiday, and Wednesday. So we'll always pick those people up without having to have someone in. We don't have a prosecutor available on Tuesdays or on Fridays. So there's no way that they can get any kind of a plea bargain at that time, because we simply don't have the person there. And it won't logistically work out to have an on-call prosecutor as well as an on-call judge where it needs to be done. So Fridays is different, though, because if somebody came in late on a Thursday and we couldn't see them until Monday, then we'd have a Riverside problem.
Who prosecutes your trials if there's no prosecutor on Friday?
Well, if we have a jury trial, then we do. So we know well enough ahead of time if we need a prosecutor on a Friday jury trial.
Okay.
But I'm talking about if we just had a Friday in-custody advisement, we wouldn't typically have a prosecutor available to us on those days.
Bruce. Jim, there was, I don't know if this necessarily fits under the on-call procedures versus the next one, which is GAFs, but it has to do with probable cause warrant procedure. And there's some more feedback, or there's some feedback from Chief Coogan. As you've seen this, I think you were copying on this email. Yep. Can you provide your thoughts as to just where you guys are in terms of integrating the procedures so that the police department and the court are both in alignment?
And there's actually two things that we've been kind of going on. I think one of the things I talked to you and Airport Temp Brinkman about last month in regards to the on-call procedures for the probable cause warrants. And what I tried to do there is make a system available to the police department to where they could call us if they needed a review, and they could do it as quickly as the end of a shift. And I had a proposal, and I talked to the chief about that, hadn't done anything with it, and then chief brought back that it would be probably inconsistent with what they had been doing, and there were some problems with it. And probably the biggest problem is most of the time that the police department is going to contact a municipal court is only going to be in cases where there isn't a equivalent state offense. And if there's equivalent state offense, then they're going to contact the district attorney for the 18th Judicial District, which covers Arapahoe County and others. And they're going to get their warrants reviewed there, and they're going to provide something to a state judge, a county court judge, as opposed to a municipal judge. It's only in kind of cases where we would have municipal ordinance violations, something that's going to be filed or has already been filed into municipal court, that they would contact us on those. And so after talking to the chief about that and the other judges, we decided not to change the procedure. As far as what you're referring to here is a procedure where officers can walk through to get an arrest warrant for a municipal ordinance violation. And there was a procedure that was adopted last April by Judge Kimmel before Judge Hammond or myself was here and implemented. And when we came in, we didn't do anything with it. We had some thoughts on how to change it, but until we had a presiding judge, we didn't really want to address it. Well, now that I've been here, I said, well, this is one of the things I wanted to address, because what I wanted to do was streamline the procedure to make it easier for the police department to obtain a municipal warrant. And in October, on one of our busy Wednesdays, I had a couple of officers that came through and had a warrant request on a case that had been rejected by Arapahoe County. And the officers wanted to obtain a municipal arrest warrant. So they brought it in, and I saw some problems with the form of it. And the very next day, we happened to have our judicial team meeting, which is something with the police department and the court clerks and the deputy city manager, and we had tried to have players from all of the affected individuals be able to meet. And my hope is to meet on a semi-monthly or a quarterly basis to try to streamline procedures, talk about things, and try and make solutions when a problem comes up. So it just so happened that the day before was the day that this had come through. I brought up some suggestions on how it could be done, and talked to the city attorney about getting what was done before so we could just kind of modify it to update the procedure on what I thought would work best. Part of it was simply getting some time available to the police department so that they could not have to wait around because they're busy and there are things that they need to do simply to get a warrant. And on that particular day, it was like the perfect storm. We had a large number of people in the Wednesday morning. We had people that were in custody for the 11 o'clock advisements. We didn't get done with the people who were there in the morning until probably about 11:20, so the jail was already waiting for us. We tried to get those going. We had a technology problem, again, with our video. By the time we got done with the people in custody, talking to the city attorney, the prosecutor for a plea agreement, disposing of those cases, it was past the lunch hour. Finally saw the officers after that. Again, had this problem, this technicality that I had. So it ended up being the worst possible situation. One of the things we brought up at our judicial team meeting was that there's times available in the day, particularly between 8:30 and 9, and between 1 and 1:30, when the court's there and the people have not yet seen the prosecutor so as to be available for us to deal with their cases in the courtroom. And that's time when I'm there, I'm usually trying to deal with other warrants and failures to appear on the mail-in fines and letters from people who aren't present, or all these type of things. And we said that's the perfect time for officers to come through requesting these warrants. So we have made available to the police those times. So if they know that they've got an application, and they can come in at 8:30 or 1:15, and we can see them immediately because there's no conflicts with our time at those points. So that's part of what we tried to do. The rest of it hasn't been changed yet. My policy, the way I want to handle things, is to, if it involves a department, if it's going to involve the city attorney, contact the city attorney. If it's the city manager, contact the deputy city manager. If it's the police, contact the police. Here's what I am proposing. What do you think of it? And so the letter that I got back from the chief, I think she may have misunderstood that that was a done deal. And when I read my email to her, it did kind of sound that way. I should have put the word proposed in there, and I didn't. And I know she was out of town, so I think it kind of caught her off guard because we had some police people that were there, but it wasn't the chief, and I had not talked to her personally. I'm in the process of responding to her to make sure that she understands this is not a done deal. This is an attempt to reach out, work at something that's going to be mutually beneficial, it's consistent, it's efficient, and it's fast.
Okay.
So that's what I'm trying to get done there and still hope to do with the police department.
Okay, thank you.
We have arrest warrants that won't be issued by the county, but we do issue them.
Yes.
Why does that happen?
I think it happens in some cases because things that are important to the city, important to the Littleton Police Department, may not be as important or significant to the district attorney and to the state court system because they have so much more serious matters. For us, the most serious thing that we might have might be an assault or a motor vehicle theft. For them, they have murder, they have sexual assault, they have robbery and burglary, and things that we don't have here. So they have far more serious crimes. And when they look at the spectrum of what they're dealing with and what they can direct their resources towards, they're of course going to take those serious crimes and put far more of their resources there. So the things that fall down at the bottom, some of the theft, some of the joyriding, some of the trespasses, may not be capable of being handled as efficiently and as seriously in that system in comparison to the other things that they have, whereas in our system, they are very important and we are directing our resources towards those. So the intake department in the district attorney's office, and I've worked in a district attorney's office intake department, and there are times where we looked at something and said, although that this may technically fit our statute, we just don't see that we have the resources to vigorously prosecute this, whereas in municipal court, as it stands, we do. And so they might go out to Arapahoe County and they may get declined for a filing there, and they may be able to bring it back here to Littleton where we will accept it.
When you say we will accept that, is that the judge or the judge and the prosecutor?
It's a combination of both. Traditionally, if the police go to Arapahoe County, they're going to the district attorney's office to have them review and take the filing, do the paperwork, and then take it up to the court to get the warrant issued. Here, that would be done by the city attorney. And I think that even in the circumstances that Councilmember Stahlman was talking about, I think that the police did go first to the city prosecutor to have them review that to make sure it was sufficient. And then it was brought to me. The similar process goes in both places, but generally the screening on a state level is with the district attorney as opposed to the court.
So if it's a citation that puts it into county court in the first place instead of municipal court, and then the county court says we can't deal with this, and it then can automatically come back to be handled in the municipal court?
It depends. In the past, and that's why I think one of the reasons that the prosecutor and the city attorney augmented some of our municipal ordinance violations. If we don't have an equivalent municipal ordinance violation, then the answer to your question is no. If they were to get rejected on something like a burglary charge, we don't have a burglary charge in municipal court. They couldn't bring that back here. If it was an assault charge, because we have an assault municipally as in addition to the state, they could file those things in municipal court.
Well, see, I think that's where I was trying to head for with the question I asked originally tonight was the issues that are going into county court now, our ability to bring them back to municipal court in the first place. Maybe it's not in the first place, but maybe in at least the second place.
There's only certain things that we can write into municipal court. So the burglary, for instance, we could write it as a theft, but if it's a felony, then it's a matter of statewide concern and we can't take jurisdiction of it. Just like a DUI, we cannot handle that locally. There's only certain types of crimes that we can write into municipal court. So we can take it as what they call a lesser included offense. So for a burglary, there's always going to be a trespass. So if the DA turned down a burglary, it might come back and the detective might say, well, I'll at least get the trespass and bring it over as a different crime. But if it was filed as a felony, we're not going to have an equivalent felony in municipal court.
So is that something that we might want to talk about with our state legislators to get us the ability to deal more with those subjects?
No, because the maximum jurisdiction of a municipal court is 1 year in jail, $1,000 fine. And so our courts have traditionally been used as sort of the local court, the court where you hopefully get people before they get to that stage. But once they're at the felony stage, it's really more appropriately handled by the district attorney's office. They have the resources, they have the statutes that apply to them. We wouldn't really want to be handling those. But sometimes we do get felony filings that are turned down. That's typically the filing that we're talking about. And the one that we were talking about in these two cases, I think, were initially a felony theft and another maybe a felony trespass or something, but both turned down by the DA's office as felonies. And so rather than file them as misdemeanors in the state, we would file them back in our court because we have an equivalent misdemeanor.
It's a misdemeanor, not as a felony.
Right.
Okay.
The next topic here is gaps which may exist in current procedures, and I think, Councilmember Cole, this was a question that you brought up at the last council meeting. Is there something in particular that you had? I know you've been to our courts on a number of occasions.
I'm sorry, just a second.
That was visiting, not in front of.
That's correct. You're always welcome to visit.
No, I think it's a general concept, right? So is there something that we need to be doing in any aspect that we're not? I mean, that we can improve efficiency or effectiveness?
Over the last couple of months, since I've been the presiding judge, I've tried to meet with the various actors within the system to kind of get an idea of how they fit in, how they feel they fit in. I've met with all of my staff, except for the one person that's on maternity leave. And I'll meet with her when she comes back. I've met with the prosecutor, the city attorney, the chief of police, trying to kind of get a feel for all the type of things that we'll need. I told you at the last meeting that I'd identified kind of some 15 topics, and they varied from things like courthouse security, the fine schedule, which is one of the things that I'm going to try to do next, because based on some of the information that had been done by our court clerk, and I think by the deputy city manager, it was clear that our fine schedule is out of line with most of the metro area. And that causes a couple of things. One of the things that it causes is people to be less respectful of our laws because the penalties are different. And the most obvious example, and the most concerning to me, is the requirement for automobile insurance for drivers. In almost every other jurisdiction and in the state, the maximum possible penalty is up to a year in jail and up to a $1,000 fine. Although we have the same maximums at current, the handling of this charge by our court is a $100 fine. And what that causes to happen, what I have seen happen, is people who have repeatedly come in, picked up a ticket, figured, well, what's the chances I'm going to get stopped? And if I do, I only have to pay $100. So if it costs me $400 or $500 to pay for an insurance premium, then what's my incentive to have insurance? Well, that puts anybody who is out there at risk if they're in an accident and the other person doesn't have insurance. It's also caused people to get a binder policy or a short-term policy from a less than reputable insurance company, come in, say, oh, look, I have my insurance now, and then let that lapse so that, again, they don't have insurance when they're out driving. In most other jurisdictions, a first-time offense is not a $100 fine, it's a $500 fine. A second offense within, say, a 5-year period is a $1,000 fine. And a third time, you're looking at jail. That's not happened here. And I think because people know that, they're less likely to follow that law and be in compliance and have insurance when they're driving in Littleton. And that's something that I think is a risk to everybody that's within the city. Similarly, a lot of the point offenses here, the fines are maybe half of what they are. Now, we just recently saw the city and county of Denver is looking at essentially doubling most of their traffic fines. And I think in their case it's for revenue generation because their budget is hurting so much. But they were kind of more in line with what we had been, and they're looking at significantly changing them. In the area, the metro area around in similar jurisdictions, Centennial, Sheridan, Aurora, Lakewood, Englewood, we have some statistics that show that we are quite low in our offenses for our fines. And the way that we handle people with prior violations is inconsistent with what's being done there. Generally, if I look at somebody who has, say, a 2-point violation and they have no prior offenses in the last 10 years, it appears to me that that person should have a lower fine than someone who comes in with the same 2-point violation and has a ticket every year for the last 10 years. That other driver isn't changing their behaviors on the road, isn't being a safe driver, and it appears to me, and the other judges that I've talked to, that the fine in those cases should be higher to try to encourage people to comply with the law. That's really not a part of our current fine schedule, and I think it needs to be. So we have met, we have a proposal put together. At some point when we have time to go over it, I would like to show council where I'm coming from and the numbers we've come up with so that we can be a little bit more in line with the rest of the metro area and make our streets safer for all of our citizens. That's something that I have sitting out here. That's a kind of a gap that I think we have. There's a similar gap in terms of our bond schedule. Right now, our bond schedule is we have one amount. Most jurisdictions, state and municipalities have a bond schedule that reflects the seriousness of the crime. So a general traffic offense would be on the bottom end. Something like a trespass, a crime against property, a theft would be on the lower. Something that's a person crime, an assault, a battery would be higher up. And then something like domestic violence would be at our very top. Right now, we really don't distinguish between those, and I think that that's a gap that I've identified. We have a proposed new bond schedule. That's something that I'm looking at trying to implement that in the fine schedule before the end of the year so we can start 2011 with some of these things in place. So these are some of the things that I've been trying to do in terms of dealing with the gaps, meeting with people, the probable cause warrants, the on-call procedure, the bond schedule, the fine schedule. These are the type of things that I think I'm going to bring to council's attention. I think before we had a presiding judge, we didn't feel comfortable as associate judges that we could make those changes because it was supposed to be a call by either the council or by the presiding judge. Now that we've resolved that, I would really like to kind of move forward on some of these things so that we can close those gaps.
And so are you thinking then to go ahead and set those yourself? And then just notify us?
I have the proposal. As I've told you, my position is to communicate and seek input from various players before I simply dictate that the policy is going to change. But we have done our research and we're ready to move forward. We all, as a bench, as judges that are there, feel comfortable with these and we're ready to move forward with them now that we have a presiding judge and we have hopefully the council's approval.
So I can't speak for them. I sure would welcome this sooner than later, because clearly the way you're explaining this is an issue we need to be looking at.
What are we looking at on the 14th study session? Do you have any idea?
I'm drawing a blank. I think it's one item. I think if you wanted to...
Is there any-
Redevelopment of shopping centers.
There you go. Thank you. That's a Chris Gibbons presentation.
Be a long discussion.
Are you available?
Yes.
Let's schedule this for the 14th, because I think there may be another topic that we want to discuss.
Okay.
So we can talk about perhaps what we need to do is, if you have any questions about it, set up on the 14th.
It was, you said on other efficiency?
The efficiency. Move that to the 14th since we're at 8. You okay with that? Bruce?
It's just one sort of clarification question. And you may have already said this and I just missed it. On the statistics here, for court activity, we've got warrants issued, warrants executed. And in October, last year, we had more warrants issued than executed. But year-to-date, typically, or it looks like both years, there's more executed, in this case, way more than issued. And the difference between executed and issued is what?
Okay. When somebody fails to appear in court after they've been served with notice by the officer that they need to appear in court, or in cases where somebody has been in court and fails to appear for a regular court date, be it a sentencing, a review hearing, or something like this, an arrest warrant will be issued, a bench warrant. If somebody is supposed to pay off fines and they come to an agreement on their payment of their fines and they fail to pay off their fines, we generally try to contact those people first, either by a letter. We have a policy of sending out a 10-day letter, even for the failures to appear, to give people a second opportunity to come in before we end up issuing a warrant. In those type of cases, we'll issue an arrest warrant, and that's the issuance. The executed would be when somebody is arrested on that outstanding warrant.
Okay.
And then it's cleared in the system by the arrest, posting of a bond, or if the person doesn't post a bond, they come in on our video advisements.
Okay, so this is going to be, is this the same sort of queuing issue where you've got what's more or less, some of these could be issued in a prior month that are executed in this month kind of thing?
Could be in a prior year.
Yeah, okay.
And I don't know if those include outstanding judgment warrants. An outstanding judgment warrant, we call them OJWs, are cases where people come in on infractions. Now, in an infraction case, we're not going to issue a warrant for the arrest of a person. If they got a speeding ticket, for instance, they had a payment option. They generally have 30 days to pay it if they want to, under the standard policy, and not appear. They didn't do that. They were supposed to come into court within a month's time. If they failed to come into court within that month's time, we'll send them a 10-day letter, which basically says, you were supposed to come into court, you didn't, please come in, within the next 10 days, and if you don't, a warrant can issue for your arrest, or a default can enter. If it's an infraction, generally we'll issue an outstanding judgment warrant. What that does is it notifies the Department of Motor Vehicles that the person has failed to appear. It's the same as a conviction. It's basically a conviction by default. And it's registered with Department of Motor Vehicles so that the next time the person comes in to renew their license, they're not able to do that until they clear this warrant. That way, if people get in the habit of saying, it's a ticket, it's not important, I'm going to stuff it in the glove box and pretend it didn't happen, there's a way to be able to catch those people up when they come in to renew their licenses.
Okay.
So that may include, though generally we probably wouldn't clear as many of those as we would arrest warrants.
Well, given that year-to-date, this is sort of interesting, year-to-date for 2010 through October, it looks like there's 588 issued and 1,340 executed. So is it fair to sort of extrapolate from that you guys are doing aggressively trying to clear these things and get them worked through the system and get them out of the system?
Well, we have a period of time during which we will keep warrants active, and we review warrants so that the older cases will end up dismissing those and clearing those type of warrants. Most of those probably are, the ones that are executed are ones, a lot of the immediate ones are cleared because a person could also clear it by coming into court. So if we issued a warrant and the person found out about the warrant, they might come in, they might find the old ticket, they might have gotten a call from a probation officer or something, and they come in, we'll clear the warrant because the person's now in front of us, as opposed to, because now we know that they're taking it seriously and they're paying attention to it. So that's one way to clear a warrant. They could be arrested on it, and a lot of times people are arrested very quickly after the warrant's issued because they've come into contact with police for another offense. When you get stopped on a traffic stop, they ask for your date of birth, your driver's license, and they run it to the system to try and find any wants and warrants, and if they do, they'll arrest you on those. So we'll get a lot of those that way. And then other ones are ones that may have sat out for some time where the person finally comes into contact with the police and gets arrested on it. So those numbers generally should be bigger. They're a reflection of the fact that some of the warrants are older. And then some of the ones we made clear simply by our annual purging of the files. Now this year we did a significant number of those since last April as a part of the review of the warrants that were out there because of some irregularities that happened when those were originally issued. They were reviewed by the prosecutor, they were reviewed by the court. Some of those things were cleared out. I did a lot of those in May, June, July. during those off hours, during the lunch hour, during the early morning hours, and the late afternoons, so we can catch up on these warrants.
Okay, thanks.
Jim, you mentioned that you had 14 or 15 areas. One of the things we tend to do is we have like future agenda items that come up, and not to ask you to maybe regurgitate all those areas back this evening, but maybe sharing a list of those areas and when you might see those coming through your communication, seeking input, and then possibly coming back to the council for policy.
Some of those areas are things that I've actually addressed tonight in terms of things like the fine schedule, the bond schedule, the arrest warrant procedures, the court session coverage. Some of them are longer-term ones, and I think I mentioned last time, one of them is the court software, one of them is court security, one is the file system, and one is the recording system. And some of these ones are items that have budget impact, maybe something that's a long-term goal. Certainly the filing system and the software system are things that don't need to be addressed right now, but they'll affect the ability to share information with the prosecutor's office, the police department, other courts and the like. Those are things that I don't know that I would be scheduling as much. Some of them were things one of the first ones was the community service contract. We have gotten that done. I understand it's been signed. The city attorney told me we're ready to actually start implementing that tomorrow. And we're very, very happy to be able to go forward and have those resources available to us. I think it's really going to be a benefit for the city. And I want to thank the city attorney for all the work that she did on that because it was phenomenal. That's something that's already been done, and I don't know how much the council really wants to hear about that. Probably one of the things that I need to deal with in the short run, and that is by the end of the year, is the associate judges. Other than Judge Hammett and myself, everybody else's contract expires at the end of the year. I've talked to, I think, everybody in terms of what their desire is as far as re-upping on the contract, and that's something that I need to deal with here because the end of the year is going to come. And it's clear to me, even though Judge Hammett and myself are taking the majority of the time, and I don't think I mentioned the scheduling. Maybe I should just briefly go over that.
If that's all right, maybe we could talk about that on the 14th.
Sure.
Okay.
But right now, most of the court time is being done by Judge Hammett, myself, and Judge Chris in equal amounts of time. Obviously, at the end of the year, if Judge Chris does retire, then it'll be primarily myself and Judge Hammett. But we still have to have available people to cover when we can't because of conflicts, vacations, sick time, things like that. So that's something that they'll have to deal with. Many of these things are either I've talked about them tonight or they're ones that we've just talked about scheduling coming up. Those are the most important ones that I've identified.
I have a question. The filing system, isn't that being taken care of with next year's budget, if we approve next year's budget?
Council, we're trying to wrap up, so if this is a question on something that we're going to cover in a future time, can we do it at a future time?
Well, I thought that was just a yes/no answer.
Okay, yes or no?
I defer to the deputy city manager.
It's a little bit more than that. After our last meeting, judges and stuff, we, in our minds, were thinking filing system means cabinets and new folders, new procedures. I'd really rather broaden that and look at how electronically we can do this, because the attorney's office and the judge's office and the judges kind of opened our eyes a little bit more, like we probably need to think about this. Maybe bring in Wendy, the city clerk, and form a committee. And we get a lot of things that are electronically sent to us. So instead of us physically going, now I'm talking a little bit what I think the dream is, but I don't know how we're going to get there. Instead of going to a file and pulling a piece of paper out, you put in a case number, and it brings it up.
Well, I think what you're saying is no.
Yeah, and let me just clarify this because
Okay.
didn't we have a line item
Yes, we did.
in the capital projects budget that said which I think is probably what Dr. Cole is referring to, is that we presented to them. You're saying it may need to be a different scope.
Yes.
That it may need to be embellished. But I understand because we had a specific line item that you saw
Right.
during the budget process, so I know where your question's
So we're
coming
not
from.
going to go ahead and do that and then need to
Yeah.
do something else. That,
Yeah,
and the
so it
money
sounds
would-
like there's been some thinking. We gave you a number
Fine.
that you saw during budget, and there's been some advanced thinking beyond that. So it looks
Fine.
like it's still a work in progress.
Thank you.
Sort of a no.
Sort of a no. A maybe no. Counsel, one last thing is, your instructions to me and to the judge was to arrange as many of the meetings that Judge Anderson needed to have during the off time in the courts. What's happened, at least currently, is that it's because of the varying schedule in the courts and the personnel or the people involved in the meetings, it's difficult to schedule those meetings in advance because of not knowing what the court schedule is going to be on the Mondays and the Thursdays and Fridays. So I'm asking your permission to, and your instruction to the judge that he can schedule those meetings outside of the normally scheduled court time and get paid for it.
That's fair.
At least for the next, say, quarter. And then we figure out what's happening.
I think that's fair to see, what happens over a period of a quarter, how many extra hours and what it's taking, and I'm pretty happy that it sounds like there's a number of things that housekeeping wouldn't be the right term for it, but straightening up the procedures and getting it so it can be smooth flowing.
That's actually the term I use. So I think that by juggling some of the days and trying to fit the things into available time, and available time, it's tough given the volume that we've got. I'm going to do the best that I can to try to get those things done during our regular court sessions. Some of them simply can't be done because they may have to be done in the evening and when people are available, something like this. But I'm going to make my effort as best I can to try to get those done during regular court time so as not to incur any additional costs for the city.
So otherwise, that will come out of contingency money.
Well, it depends on, we'd have to look at what the budget is, and it really depends on how many hours we're talking and how many meetings and things like this. I would suspect that the need for those meetings would diminish over time as the court starts to run more efficiently, the procedures get worked out and things like this. So that's part of the reason I suggested for the next quarter, see how things go.
I'd like to see some numbers put to that. Currently, we have, with the judges, it's a 3-hour deal. Would that carry over to this? It would be the 3-hour thing, or would it be by hour?
Be by hour.
Okay. And then the other people that they'd be bringing into the meetings, would they be paid overtime if they're staff, officers, other?
Well, depends on who it is that they're meeting with. I mean, some of the examples of the meeting I'm thinking of is meetings with community service providers, potentially meetings with Phil and Jim, those types of meetings. And part of the issue is there may be time that appears as available, but it's difficult to schedule some people to come in and meet with you if you can't tell them more than an hour or a day in advance when you can meet with them. I mean, calling the clerks in to
Do you
sit
have
down.
an idea how much money it would cost? Do you have an idea what we're talking about? Is it?
Well, you want to set a limit?
Well, I have no idea what would even be a reasonable limit. I mean, I don't know what would be a low end necessary and a high end excessive, and then I have no idea.
We could just, we put together the budget for the salary for the judges, I'm just talking judges now, we estimated how many hours, 20 hours a week. So we can look at that and get that number firmed up a little bit more. But we can talk to the judge now, whether or not they're after working hours or during working hours, but not on his schedule. So if he goes over, for instance, let's say 20 hours a week, so now we can calculate there's an extra 3 hours a week for the judge. Staff, I'm not too concerned about if it's held within the working hours, 8 to 5. That's, if it's after, then we got to talk about it.
Well, I would anticipate that if Judge Anderson needs to meet with somebody and that can't be arranged during court days, that he would schedule that on Tuesday or Thursday afternoon. There's nothing scheduled on Thursday afternoon, which would then be during normal hours, but it wouldn't be during his normal hours. Or conversely, he might schedule one of the backup judges to come in during a portion of the day and do it that. That would be potentially more expensive, or maybe not.
Yeah, I don't know how many meetings the judge is going to have, but just thinking, even if we did, 1 or 2 a month, and they were a couple of hours, we're not talking a whole lot of money, but we can throw some numbers at it and just give you an estimate, counsel, of what that might look like. 2 meetings a month, for 2 hours, 4 hours a month.
I've been looking at the time cards because I sign off on the time cards before they go. I haven't seen a whole bunch of hours, so I don't think we're talking a whole bunch of time. In fact, most of what's happened so far is there have been a number of meetings, all judges meetings, or whatever the Latin term is for that. And I suspect that that will also diminish as because we have the, I want to say the court book, but what's the name of that?
Bench book.
Bench book. I mean, we've got the bench book in place now. We've got the judges that are getting experience with each other. I would expect most of the stuff to get ironed out.
And I think the mayor's correct. I don't anticipate, I think most of what I needed to do up front are actually already been done. And so I don't anticipate that you're going to see much of any things that are going to be required outside the normal hours at this point. I think I can handle that by scheduling and by using the time as productively as I can to get things done when trials don't go or when I do see some available time. That's going to be my effort to do that. I don't anticipate this being a problem at all.
So, you're okay? You're okay.
I'd like to put a limit.
Okay.
5
hours a month?
Do you think 5 hours a month is reasonable?
I think that's excessive.
3 hours. How's that?
That's fine.
I
think if you saw last month, you saw there was none.
Seeing what happens.
So I'm trying to keep it at 0. But if something comes up, I guess it would be good to be able to have something to fall back on.
Hour 20 in.
I'm not charging for this.
None of us are getting
The
paid.
issue with me is getting the job done regardless of what the hours is. And I think that's the bottom line.
Yeah, and I think if the job takes more than 3 hours to do, then so be it. If we want to put a maximum of 5, I'm fine with that. I don't like leaving things open-ended. We're dealing with a very tight budget, and I think we have responsibility on that.
All right, then. How about if we say 5 hours, and if I see it over more than 3 or so a month, we're only talking the next quarter. I'll come back to council. All right? But that gives me some latitude of approving the forms. All right. Thank you, Judge Anderson. Appreciate it. Let's take a 5-minute break, and then we're meeting upstairs for...
Do we need a motion?
Yes, we do need a motion.
Mr. Chairman, I move that we have an executive session pursuant to CRS Section 24-6-402, paren 4, paren F, to discuss a personnel matter, specifically the continuation of the city manager's annual evaluation. And at this time, are we to include
And the other one.
We also need an executive session to talk about the union contracts.
And also on the agenda would be the union contracts,
And that one's under legal advice.
under legal advice.
Section.
You can read it.
Which is
CRS.
24-6-402-4B
And
and
24-6-402, Paren 4, Paren E.
Okay.
And in attendance, in addition to council members, will be City Attorney Suzanne Steyer, Deputy Manager Phil Cortese, and HR Director Aaron Von Savage.
So moved.
And me, yes.
So moved.
For both items?
For the union negotiations, and then, as Mr. Shernanek said, just for the review will be me.
Okay, it was moved by Phil and seconded by Bruce. Takes 5 votes, discussion. All in favor, raise your hands. It's unanimous.
I thought there was a communal motion.
It was a group.
And I'm sorry, did you want to go upstairs?
We want to go upstairs. We will not be coming back and conducting any regular business before we adjourn after the executive session.